Robert, I said I've been doing homework on a Sunday. Um, kid's going to be pissed when he sees that I took one of his drawing papers. Let's start. We got to start. We'll start with the Flynn saga, the Flynn hearing, because I know I've got questions, and anybody, you don't feel obliged to put a super chat in. I'll try to get your questions about the hearing. Robert, I mean, you saw I imagine maybe you didn't see my summary. I was genuinely surprised at what I felt to be not a low level of law, because I don't want to. It's not like that, but I wasn't impressed with the hearing. It sounded very, I would say, almost amateur. I was taken aback by the amount of hypotheticals, how far they went with the hypotheticals, and the length to which they used hypotheticals instead of concrete examples. I mean, is that normal in the Court of Appeal?
Not precisely. I mean, to some degree. In other words, the hypotheticals, when used well, are designed to define the outer boundary of the policy impact of the precedent that they're about to write or publish. So to the extent that that's where they were at, then that was acceptable. But the problem was twofold. One, some of the hypotheticals really didn't go to anything that related to this case or would be impacted by this precedent. And the second one is they were almost all one-sided. I would have been more aggressive than either Sally Yates or the government was. I would have, when they started going that hypothetical about corrupt prosecutors and whatnot, I would have said, well, here's why we have the separation of powers. Let's say we decide that the government decides they think Judge Sullivan is doing what he's doing because he took a bribe from, I don't know, a Barack Obama ally. And so consequently, we, the government, are going to decide to grand jury the judge to inquire into all of his reasonings for why he's been doing, what he's been doing, and what he's been saying, just to make sure Judge Sullivan didn't take a bribe from an Obama ally. That would have pushed back and exposed the other side of the problematic aspect of their precedent. If the judiciary is not going to respect separation of powers for the executive branch, then why does the executive branch have to respect separation of powers for the judiciary? So this is why separation of powers exists. It isn't just so that the judiciary doesn't overstep on the executive. The judiciary, by not overstepping on the executive, creates a quid pro quo effectively where the executive won't overstep on the judiciary. I would have been much more aggressive. I wouldn't have been as kind and cordial to some degree as the others were. Also, I would have gone that route to be inflammatory, to point out the extreme consequences of the dangers of where they're going, not only to show the perilous aspects of the precedent they're about to publish, but also because once you're facing a panel that going in you should know is going to be overwhelmingly against you, given the 7-3 Democratic lean. And once you understand how judges operate in a political case, you understand that's where they're going to go. Then you need to, in order to change the equation, you need to throw some grenades. And sometimes lawyers don't understand why I do this in some cases, but it's when you can see that, okay, if this goes normal, my client loses, then what's the downside? What, the same thing that was going to happen anyway happens? So what? You might as well throw some grenades to see if you can change the equation. There are two judges who are amenable to a compromise outcome in this case. And what I said was I thought the Clinton judges were they needed to convince one or two of the three Clinton judges or convince Serenivasan. And I probably mispronounced his name. I'm just going to call him Siri after the app, the little device, because I can't pronounce his name. So, but Siri's the chief judge. He's an Obama appointee. He served under the Bush administration, though, as well. And it's an open secret in D.C. that he thinks he's going to be on the U.S. Supreme Court. So for him to preserve his access to the U.S. Supreme Court, he knows he needs to not offend and upset unduly Republicans in the Senate. And so the best way for him to do that would be to come up with some sort of compromise that isn't a pat on the back to Sullivan or a slap in the face to Flynn. And so that's why you saw him exploring different places. Then the one Clinton judge, it was not a surprise that the woman Clinton appointee would be a no-go. In my experience, women judges, particularly women Democratic judges, they are the demographic that if you did a poll, hate Trump, hate beyond all reason. So the probability they do anything that could be positive towards Trump was a no-go. Garland is obviously still ticked that he got he didn't get on the U.S. Supreme Court like he thought he was going to in 2016. That came out in some of his questioning. So it was left to the last one, Tenet. And he asked him, I think it's Tenet, I may be mispronouncing the name, but that judge is the one who said something that actually probably should have been thought about by the government all the way through, which was when I ask for writs, you can ask for a writ of Mandamus, which is the Court of Appeals ordering a district court to do something. Or I always often phrase it, or in the alternative, a writ of prohibition. The reason is sometimes it's interpreted that what you're really asking for isn't an order that they do something, but is an order that they not do something. Notably, he acknowledged in the hearing that, in fact, that was an appropriate remedy here. Now, nobody's asked for it, so they may evade the issue, though they have the inherent authority to extend it to a writ of prohibition. Because what really everybody was saying was it's the appointment of the amicus, the delay of the hearing, the inquiry into contempt that is the problematic aspect. Opening the door to potential subpoenas and evidentiary hearing, that's problematic. What they could have asked for is a writ of prohibition to prohibit him from ordering the amicus, prohibit him from having the amicus do anything further, prohibit him from basically doing anything other than holding a oral argument and issuing a ruling. If they're an honest court, or if Siri is smart and sees that as an effective compromise, that's what they'll do. And not only will they do that, they'll add in a disqualification. Now, you see they've come up with another excuse for why they can take the case en banc without Sullivan having standing.
That's actually, yes. Someone had asked, the court, it was Rickerfield. He said, why didn't the court address the fact that they made Sullivan a party to the suit? So this was a little complicated where they were talking about, is it sua sponte that they use the term?
Yes. And it is true they can sua sponte do it, but they didn't. So, I mean, I get it. They're going to retrospect and say, we could have, we're going to say we did it sua sponte.
Explain what sua sponte means for those who may not know.
It's Latin for on their own authority, or literally just means sua sponte is where the word spontaneous comes from. So it means on their own accord. They can spontaneously, if you will, take action regardless of what. They don't have to have a party request relief. They can, in this instance, say that we believe we need to take it.
Yeah, except now, and I had pointed that out. They didn't do that, though. Nobody did it. Sullivan did it, right. And by doing it, made himself a party. And then they said, well, I don't know who brought up the issue of disqualification, but they bring it up. And then they say, well, we could have done it on our own, except we didn't. And because we could have, therefore, he hasn't made himself a party. Didn't make sense.
No. And it was the same. It was one. It may have been the same Clinton judge, but or may have even been the judge. Forget which judge it was, but it was a judge who also pointed out that this was all a circus at this stage. That ultimately only one outcome can come about. Why are we messing around and delaying that outcome? That was a judge that was otherwise hostile. So I think what you're seeing is the 3 Obama judges and the 1 female Clinton judge clearly want Sullivan to be affirmed with no limitations, no disqualification, nothing. Siri and Siri and the Clinton judge, the one dissenting potential Clinton judge, are the ones that are going to decide the case. Because if both of them break, then you would have a 5-5 split. And you can't reverse en banc on 5-5. They need 6-4. So so it's going to be up to Siri. Siri has a lot of influence as the chief judge. He's the intellectual heavyweight in that group on the Democratic side of the aisle. He's the practical one, pragmatic one. Think of him as like a Justice Roberts of the left. And you have a sense of who he is.
He sounds very smart. Incidentally, you're going to get totally nailed because apparently mispronouncing names now carries with it certain consequences.
Oh, yes. Which was fascinating. It was amazing watching the media say that mispronouncing Kamala Harris's name meant that you were being racist. Apparently, they didn't know that that's an Indian name. That's not an African-American name. So they're like, this is anti-black. I was like, well, if you want to make an argument anti-Indian, okay. But everybody mispronunciates names from certain. I mean, there's Polish friends of mine in Milwaukee. From Wisconsin Law School, I just quit pronouncing their name. I was like, there's no way I'm getting that last name.
Well, my last name's Freiheit, so I get Freiheit, but whatever. No, it's all the same. So,
well, in Spanish, I'm Barnes, which actually I almost like better than Barnes. It sounds more like authoritative. Roberto Barnes. And I was like, oh, okay, I'll go with that.
So Srinivasan was very logical and meticulous. But so in the outcome, if it's 5-5, then what happens? The order remains vacated because they vacated the panel's decision, and it goes back to Sullivan and the amicus?
Yep.
Oh, exactly would that be a circus? Holy cow.
Normally, they don't have even numbers. It's because they had to recuse. The Trump judge had to recuse. Otherwise, they would have had odd numbers, but they have even numbers. So so that's where I think what will really happen is Siri will use his authority to push everybody to try to be on the same page. So I think it's going to be some sort of hybrid decision. Put this way, if they come down and they just affirm him, don't disqualify him, don't do anything to him, it will go. I'm sure either the government or Flynn's counsel, Sidney Powell, will petition the U.S. Supreme Court. Now, no assurances about what they'll do, but there are really unique facts here. So that's where I think Siri wants a decision that would preclude a Supreme Court taking the case without,
preclude setting a precedent that's going to come back to bite them in the not so near future, or everybody, and undermine basic separation of powers.
Exactly. And what they could do is they could just convert it to writ of prohibition.
So I want to get to that in a second. Thanks Scuba Steve for the super sticker. There was one comment here. You both look great. Grenades, yes. No, that wasn't the comment, but thank you very much, Vicky. Maybe briefly touch on the concept of legal fiction re the Flynn case. I'm not sure what you mean by that. I think maybe we were getting into the discussion earlier, but STF.
Mark Geragos is a moron.
Yeah, so
here's my mantra, my advertising pitch for Mark Geragos. If you want to lose, hire Mark Geragos, because nobody loses like he does.
I think you're mispronouncing his name also. I think it's Mark Geragos.
That may be deliberate in the result of prejudice, I confess.
So he says, have you heard Mark Geragos re Flynn? Unbelievably tedious in his analysis, legal eagle level subject.
The guy's just not smart. I mean, he was about to get Michael Jackson convicted until Michael Jackson figured out the guy was a moron. He did get Scott Peterson convicted. I mean, name a big case where the guy wins. I mean, the only thing he did is he managed to dodge getting. I mean, he's defending Jussie Smollett, to quote Dave Chappelle. So I can't be accused of prejudice because I'm using Dave Chappelle's pronunciation of Jussie Smollett. So and then he was connected to the Avenatti case, and I'll give him credit for dodging indictment. Congratulations on that. He's not a bright lawyer. He's very good at working the media, lousy at defending people at trial.
Well, he's arguably not so good at working the media because he got himself in a defamation case for things he said about the Osundaro brothers in the Jussie Smollett case.
I used to tell people the reason I opened an office in L.A. in California is I figured if an idiot like Geragos could get big cases, then this is open territory.
We got Corliss SD says, Barnes, re-separation of powers. Isn't it the fact that the FFs didn't intend for SCOTUS to sit in judgment on the actions of the other two, such that either need to pay attention to SCOTUS, a Chief Justice Marshall creation?
Yeah, what he means is Justice Marshall years ago decided that only the court gets to decide what is and isn't constitutional. Because the question, now that isn't always true, but here was the theory. Who gets to decide whether their actions are constitutional? Does the executive branch get to say, well, we have a duty to uphold the Constitution, so our final determination about our actions being constitutional is in fact final and not reviewable by the court? Same with the legislative action. Justice Marshall said, no, we the court are in a unique position to be the final arbiters of what is and isn't constitutional. Now, they don't always do that. There are places they use the political question doctrine, standing doctrines, mootness doctrines to effectively allow the executive and legislative branch in certain contexts to be the final say on what is constitutional. Impeachment's one of those examples. Other examples are foreign affairs in certain contexts. So but yeah, that's what he's referencing. There are a lot of legal scholars who were critical of Marshall's interpretation that the judiciary was intended by the Constitution. FF, I assume they mean founding fathers, to be the final arbiter was constitutional. But Marshall did have some pragmatic arguments for it. His argument was, look, we don't have the power of the purse. We don't have the power of the sword. So us having the power of the finality as to what's constitutional makes sense because we're the least likely to abuse the constitutional in that time frame. That hasn't always proven true, but that was at least the logic, and there was an argument in his favor.
Okay, it's very interesting. And someone's the last says Barnes need to bring up the Free American Law Center more. We need a new ACLU that has not lost all impartiality.
That's for those who don't know, I helped co-found an organization called Free American Law Center that's designed to be sort of an ACLU for everybody, since the ACLU has abandoned people based on their political persuasion. So people can go to freeamericanlawcenter.com. They can join. It's a very low monthly subscription rate. I provide access to I try to provide access to podcasts, videos, things like this, to make people informed and available and provide other information. But mostly it's to support an ACLU that actually meets its purpose and principle.
And speaking of political bias, I mean, the one people can, confirm whether or not they have the same sentiment, because I don't often listen to American Court of Appeal hearings. I was shocked and it's a double-edged sword. But I was just shocked that you knew you could Google who was appointed, you knew where they were going to go, and they went there with such. No, I won't call it bias or partiality, but just with
it was over the top,
predetermined notions.
Exactly. The problem is that the liberal courts. Your point was very well taken, and it's the normal reaction of people who have not seen our justice system up close. It's a very deeply unsettling reality when you realize that the political partisan label of the judge will dictate how that judge will rule in any politically tinged case. And it's an unfortunate. It's gotten worse rather than better. I know people have commented and say, "Well, do Republican judges do the same?" Well, yeah, because I'm predicting them too. So, but the difference is this: on the political right, within the legal academy, they believe in the rule of law, and so that's why it is far more likely that you'll see a Republican cross over to vote with Democrats than you'll see a Democratic appointee cross over and vote with Republicans. Democrats increasingly. I'm sorry. Go ahead.
Oh no, I was just going to say. I think it was Millett. It was almost like she was arguing Sullivan's case for him through Wilkinson in the questions she was at Beth through Beth the questions she was asking him. It was outlandish. I mean, it was like she was asking the rhetorical questions in the way that framed the argument that she wanted the lawyer to present to her, and then went with it. And it was, I don't know if it was Millett in particular. There was just one. It was over the top.
Oh yeah. There were several that were really bad. I mean, and Warren Rogers was really bad, the female Clinton appointee. So they're over the top, and what is there's fewer pragmatists up there. So the fact that Garland wasn't pragmatic, now maybe he would have been before the whole Supreme Court experience, but I was disappointed in that. The at least Clinton judges typically recognized, okay, what's our political risk on the other side to the integrity of the judicial process, et cetera. And unfortunately, there was very little of that. So it's a bad sign for where the courts are, that with a judge doing something outlandish and outrageous like Sullivan is doing. And by the way, the exact same DC Circuit turned around and immediately granted an emergency writ of mandamus to prevent Hillary Clinton from being deposed by Judicial Watch in her FOIA case.
Perfect segue. And it's an interesting thing in that case. Now, I forget the judges. It was a unanimous decision, I believe, in Clinton, right?
Yes, it was just a panel decision.